We have the last presentation for the day, I think. Mr. Rishabh Bhandari.
A very good evening, everyone. The panelists, participants, and everyone else who has given their precious time to this conference. My name is Rishabh Bhandari. I am an assistant professor of law at Ramaiah College of Law, Bengaluru, India. Now, so far I've had the opportunity to teach 9 legal subjects, but particularly last semester I was teaching criminal law, wherein interestingly a lot of changes happened. So the Indian Penal Code, which used to exist in India since 1860, has now been replaced by Bharatiya Nyaya Sanhita, effective from July 1, 2024. So I thought, why not take this opportunity to do a good research on it, try have a basic attempt to bring out the potential impacts of this change. Now, to briefly put the reason behind the change, it's very simple. IPC, which had been existing since 1860, was an outdated law. As we all know, laws are supposed to be contemporary to the existing societal norms. So, if there is any law which is not reflecting any social reality, that law needs to be updated. So, similarly, there were many laws in IPC that were outdated, and that was the reason behind it. Now, more importantly, coming to the main point of this research, what has been the impact of this change? Now, originally in my paper I have mentioned 12 such impacts, but given time constraints I am going to limit it to only 6, and that too briefly I am going to explain them. So number 1 I would like to mention is the emphasis on Nyaya. Now Nyaya stands for social justice. So as we understand the purpose behind any law, and there are different theories of punishment, is as such that wherein one such theory is retribution. Retribution in another way can also mean an eye for an eye, which is based on the concept of revenge. Similarly, there is another theory which is that of deterrence. So, while retribution talks about taking revenge, deterrence talks about the idea of ensuring that a person who is committing an offence, if given a certain punishment, does not go on to commit the same offense, or other people looking at that person do not go on to make the same mistake or commit the same crime. That is the idea of deterrence. But then there is another theory of reformation. So reformation is that theory that I am talking about here when I talk about BNS's first impact, which is emphasis on Nyaya. Now, how has BNS ensured that it comes into picture? It has talked about a concept that has never been talked about in India, that is that of community punishment. So, community service. Now, community service is now another kind of punishment that has been added to different kind of punishment that are there in BNS. So, that is the first thing that I wanted to mention, which is a progressive change. Now, coming to the second point it is mob lynching. Now, the introduction of the offense of mob lynching is something that I want to talk about because of the occurrence and the frequency of its occurrence. Now, there are crimes like murder and grievous harm that are committed in general. But the idea behind mob lynching is when same offences are committed by people in group, and particularly for reasons such as caste and religion. So another such major change has been the introduction of this new offence of mob lynching, which again is a progressive change because it is going to have a great deterrent effect on such groups who go on to perpetuate this tendency of committing offences based on things like caste and religion. Then the third thing that I want to quickly jump on is snatching. Now, snatching, as petty as it may sound, is an offence which is committed very frequently and much more frequently than the offence of theft. Now, even though in general when you sit and think about theft and snatching, you may think that they are the same things, but in reality when we apply the principles that are required to commit the offence of theft, they are pretty different from that of snatching. Number 1, snatching is something that deals with immediate force or something that can lead to a much greater harm than that of theft. Number 2, in theft, it is not necessary. There is a greater chance that the person who is the victim is not even aware of the offence that is happening. But in snatching, it is the opposite. So that is why again, the very reason why any crime is made a crime is to ensure that people residing in the given society, in the given country, are having that deterrent effect. Knowing that now it is a crime, they will be much more likely to think 10 times before doing about such a thing. Now, while I have talked about these three changes that have been rather positive in nature, of course we realize that nothing in this life, nothing in this world is short of its shortcomings. So, as there are pros, so are there cons. So, just like that, I am going to talk about a few negatives of BNS, which in my opinion are negative. Now, the very first one of them is retention and renaming of sedition laws. Now, sedition is something that was enacted again in IPC only in 1860, but the idea with which it was enacted was to suppress dissent. Now, it is the same offense that prevented our freedom fighters, as in the Indian freedom fighters, from ensuring that they went on to express their freedom of speech and expression. So, while this law was outdated till 2024, when BNS was supposed to come into picture, the idea was that this law would be replaced. Why? Because we are living in a modern India, we are living in a modern country. So, even though the exact wordings have been removed from the given law as the law has been repealed, the nature remains the same, and that is something that is very problematic. Words like subversive activities and feelings of separative activities are very subjective words that can be very well used by the government to oppress the voices of the dissenters. And dissent is something that needs to exist in any democratic society, which again makes it a negative retention in my eyes at least. Then the last two things that are remaining, the first one of them is lack of recognition of marital rape as a crime. Now, the idea behind lack of recognition of marital rape as a crime is that if there is a person if there is a man who has wedded a wife, and if they are in this ceremonial institution of marriage, it is the man's right to have sexual intercourse with the wife, and this right is irreversible in nature. This is the idea which is the basis for the exception that is there under the offense of rape, that which says that sexual intercourse or sexual act by a man with his own wife, the wife not being under 18 years of age, is not considered as rape. Now, let me get a little bit further. I'll just take 15 more seconds to get you to the point how this thing got incorporated in India in the first place. So there was a man called Matthew Hale. He was a very famous jurist in the 17th century. However, he made this observation that since marriage entails an irreversible permission from the woman to engage in sexual activity, a husband cannot be found guilty of raping his wife. Now, again, ladies and gentlemen, we need to understand that this is 17th century that we are talking about. So to a very good extent, it would have perhaps made sense in that barbaric society, in that Victorian era. But in today's time, however, are we to say that a woman does not have enough sexual autonomy to decide whether she would like to have sexual intercourse with a man the moment that man becomes his husband? So that is a question that we must ask ourselves. And the last thing that I want to focus on is elimination of section 377 of IPC in entirety. Now again, the background of section 377 is that as it used to exist from 1860 to 2009, that's almost 150 years. For 150 years in India, homosexuality was criminalized. Finally in 2009, Delhi High Court judgment decriminalized it, but then again it got the action got undone by Supreme Court judgment in 2013. The name of that judgment was Suresh Kaushal versus Union of India. Then a curative petition was filed, and finally in 2018, in the progressive judgment, very well celebrated across the entire world, in the judgment of Nas Foundation versus Union of India, homosexuality was decriminalized. Now the thing is, even though homosexuality has been decriminalized, there are other things that section 377 deals with, and they include aspects like having sexual intercourse with an animal or a dead body. As weird as it may sound in our general discourse, it is a reality. If we follow news, we would have the statistics that there are people who dig up dead bodies from the grave and who target animals for sexual purposes. As sad as that reality may be, it is a reality. And again, the question that we need to ask ourselves at this moment is, what are we doing to protect the rights of those animals or to protect the rights of those dead bodies or the families of those humans who are now dead, so as to protect them from such offenders. So these are my observations that I wanted to put across, and in conclusion I would just say that while BNS has been a significant updation in Indian criminal justice system, it still has a few shortcomings, and how well the BNS goes on to operate in the future will depend upon its implementation and how soon and how well the suggested recommendations are implemented. Thank you very much, everyone.